With the recent approval of the Pfizer vaccine for 5 to 11-year-olds, many are wondering when their recommendations to vaccinate will become a mandate. Do governments have the legal authority to intervene in a family decision? And if so, under what conditions? Now, one opinion comes from a case out of the Second Circuit in the 1970s. Now, understanding the limits of the coercive power of government over families will be important if we wish to remain free. So we'll discuss that next on the Constitution Study.
You have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans, and welcome to the Constitution Study. I'm glad you could join me. As always, you can find out more about the Constitution Study at constitutionstudy.com. Now, I recently returned from a trip to Tampa where I had several engagements talking about the Knowing Your Rights tour. I had a great time. I met a lot of great people. If you are one of them, I wanted to let you know I enjoyed myself. I hope you did too. And if you'd like to find out more, and if you'd like me to come speak to your group, well, just go to constitutionstudy.com/tour and find out more. And I'll talk about more of what's going on at the end of the video. But for now, let's talk about this 1970s case. Parents are responsible for the health and welfare of their children. This fundamental truth should be at the bedrock of family law in America. However, not everyone sees things that way. In 1977, the United States Court of Appeals Second Circuit confirmed that children are not the property of the state, except in extreme circumstances. The name of this case is Duchesne versus Sugarman. Let's start with the circumstances that led to the case. In December 1969, Pauline Perez had two minor children, Danny, age 7, and Marisol, age 6 months. Now, on September 16th, Ms. Perez decided she needed to seek medical attention for her emotional problems. Expecting to be treated as an outpatient, Ms. Perez left her two children with a neighbor. Instead, Ms. Perez was admitted to Bellevue Hospital, where she remained for the next 6 days. The neighbor contacted police, informing them that she could only take care of Ms. Perez's children for the night, as she was about to give birth to her own child. But the police relayed this to Welfare Center, and they contacted New York City's Bureau of Child Welfare, or BCW. Now, on December 17th, a BCW representative visited Ms. Perez in the hospital and asked her to sign a form granting consent to the Bureau to take custody of her children. The Bureau rep told Ms. Perez that she would not lose any parental rights, and as soon as she was released from the hospital, her children would be returned. However, Ms. Perez refused to grant her consent that BCW take custody of her children. The BCW employee informed his supervisor, James Prinzler, of Ms. Perez's refusal to consent. Prinzler advised the caseworker that consent was not necessary at that point. The same day, BCW assumed custody of Ms. Perez's children, placing Danny in St. Joseph's Home for Children and Marisol in the New York Foundling Hospital. Records from both BCW and the two institutions indicate that the emergency placement was requested by BCW because the children's mother was in the hospital. No mention was made that the mother had not given consent and that BCW had not gotten a court order to take custody of the children. This appeared to be in accordance with city policies at the time. Now, on December 22, 1969, Ms. Perez was released from Bellevue Hospital and immediately contacted a BCW caseworker demanding the return of her children. Her children, however, were not returned by BCW. Several days later, Ms. Perez voluntarily returned to the hospital until February 1970. Upon her release, Ms. Perez once again contacted BCW for the return of her children. Once again, her request was rejected. On January 22, 1970, a deputy commissioner authorized St. Joseph's to admit Danny into foster care because of the mental illness of the person caring for the child. Then on March 2nd, a similar authorization was sent to Foundling Hospital for Marisol. This means that the children were no longer in emergency temporary placement, but in long-term and possibly permanent care. On April 29th, the psychiatrist treating Ms. Perez recommended the children be returned to her one at a time. The BCW reported this recommendation to the two child care institutions, but they objected and the children were not returned. For months, Ms. Perez repeatedly requested the return of her children, all of which were denied. During this time, the children were not even allowed to visit each other. Then in October 1971, Ms. Perez found that Marisol had been transferred to a foster home without her knowledge. All of Ms. Perez's complaints to various authorities that she never signed any papers were apparently ignored. Now, records show that at least as of November 10, 1971, BCW, St. Joseph's, and the Foundling Hospital were aware that Ms. Perez never signed any consent or commitment papers. Apparently, they discussed the absence of consent but decided to take no action unless Ms. Perez initiated legal proceedings. Now, records also revealed that, quote, since obtaining Pauline's signature at this point seemed an impossibility, they agreed not to attempt it. Now, on February 22, 1972, 27 months after her family had been separated, Ms. Perez filed a petition in the New York Supreme Court seeking a writ of habeas corpus, or produce the body. Now, only after Ms. Perez filed her petition did BCW and the two child care facilities file a neglect action against her. These two actions were combined and heard in family court, which denied Ms. Perez's petition for habeas corpus and found Ms. Perez guilty of neglect. The appellate division reversed the family court's decision, finding that the initial removal and continued detention of the children was done in violation of state law due to a lack of Ms. Perez's consent or a court order. Furthermore, the appellate court reversed the family court's finding of neglect because Ms. Perez was denied the opportunity to present evidence in her favor. Now, this is where the case goes to the Second Circuit. The threshold inquiry is whether the evidence established that appellants have been deprived of a constitutional right. They assert that the removal and detention of the children with neither parental consent nor court authorization, and in the face of the mother's repeated request for their return, deprived them of their right to live together as a family without due process of law. The crux of the claim is the appellees could not constitutionally refuse to return the children to their mother's custody without providing an opportunity to be heard at a meaningful time and in a meaningful manner. Now, can the state take custody of your children without your consent or a court order? That was the question the Second Circuit was dealing with. As the court stated, it is beyond peradventure that freedom of personal choice in matters of family life is one of the liberties protected by the Due Process Clause of the 14th Amendment. So what is this Due Process Clause of the 14th Amendment? Well, it states, nor shall any state deprive any person of life, liberty, or property without due process of law. As the court points out, the liberty to live as one sees fit without governmental interference can only be abridged legally by due process of law, which the Free Legal Dictionary defines as an established course for judicial proceedings or other governmental activities designed to safeguard the legal rights of the individual. Some people say the process is the punishment. However, when it comes to the Constitution and laws of the United States and of the several states, the process must protect the rights of the individual. As the Second Circuit noted in their opinion, here we are concerned with the most essential and basic aspect of family privacy, the right of the family to remain together without the coercive interference of the awesome power of the state. This right to the preservation of family integrity encompasses the reciprocal right of both parents and children. It is the interest of the parent in the companionship, care, custody, and management of his or her children, and of the children in not being dislocated from the emotional attachments that derive from the intimacy of daily association with the parent. The mutual interest in interdependence relationship has received consistent support in the cases of the Supreme Court. The court pointed out that the most basic aspect of family life is the right of a family to remain together without the interference of government. The Second Circuit then gets to what I believe is the crux of the matter. The trial court concluded that the initial custody in December 1969 was clearly proper since the facts show an emergency situation with the mother in the psychiatric ward of Bellevue Hospital and no one to care for the children. We agree that the evidence establishes that the taking of the children was justified at the outset by an emergency. As such, as a matter of constitutional law, the initial removal of the children without parental consent or a prior court order was permissible. However, in those extraordinary situations where deprivation of a protected interest is permitted without prior process, the constitutional requirements of notice and opportunity to be heard are not eliminated, but merely postponed. Was BCW legally authorized to take Ms. Perez's children into custody? Since there was no one to take care of them, the answer is yes. What we have here is what the law calls an exigent circumstance, requiring immediate action, pressing, and urgent need. See the synonym as urgent. Since the mother was hospitalized, there was an urgent need to find someone to care for these children. The mother had not given her consent to the BCW, and there was not enough time to get a court order. So BCW took the children into custody and placed them in appropriate child care facilities. At that point, BCW had acted within the law, but then things went off the rails. When Ms. Perez was out of the hospital and contacted BCW for the return of her children, she was denied. BCW relied on a previous case, Boone versus Wyman, which challenged a New York social services law that provided that once a child was remanded or committed to an authorized agency, the parent was not entitled to custody without the consent of the authority or a court order. There was one significant difference between Boone case and Perez's. So in the Boone case, Ms. Boone had granted her consent that a state agency take custody of her children. In Ms. Perez's case, not only did the BCW not have her consent to take her children into custody, they did not even attempt to obtain a court order until 3 years after their initial emergency action. By denying Ms. Perez custody of her children, even denying her the chance to challenge BCW in a competent court, BCW had denied her the liberty to live with her family without due process of law. Now, what does this 1970s custody battle have to do with possible vaccine mandates? The answer comes from the concluding paragraph of the court's opinion. If a state were to attempt to force the breakup of a natural family over the objections of the parents and their children without some showing of unfitness, and for the sole reason that to do so was thought to be in the child's best interest, I should have little doubt that the state would have intruded impermissibly on the private realm of family life, which the state cannot enter. Before the state is legally allowed to intrude into the private realm of the family, there must be some showing of unfitness. In other words, the state must show actual harm to the child, not merely what the state believes is in the child's best interest. To claim the authority to require a vaccine, the state must show that the child is in real physical danger from the disease, and that the vaccine is the only viable remedy. A simple look at the CDC's own data shows neither statement to be true. While the 5 to 11 age group makes up 8.7% of the U.S. population and accounts for 5.6% of the cases, 0% of the deaths, only 192 deaths total, have occurred among this group. As we see governments at all levels claiming the authority to tell us how to live our lives, it becomes more and more important that everyday Americans not only know their rights, but the laws that protect them. So if your school starts demanding that your child receive a COVID vaccination, point them to the Perez and Boone cases. Point out that without a court order, any attempt to vaccinate your child without your consent is battery, and that you would seek prosecution to the fullest extent of the law, along with civil damages. As John Jay said, by knowing their rights, they will sooner perceive when they are violated and be the better prepared to defend and assert them. To be forewarned is to be forearmed. If we are to fight for our rights and liberty, we must be armed with both the truth and the law. Hopefully this episode has helped you protect not only your rights, but also the rights of your children. So what do you think? Going all the way back to the 1970s. I actually lived in New York City in the 1970s, although as a child I was completely unaware of this case. But it shows that, at least at one point, the state recognized that children are not under the control of the state unless the parents are shown to be unfit. Simply because the state thinks that a vaccine is the best thing for your child doesn't mean it is, and it doesn't mean they have the right to vaccinate your child against your consent. It also doesn't mean they have the right to remove your child simply because they don't like the way you are raising them. It's an important understanding not just of family law, but of the basic concept of parental rights. See, being a parent is an awesome responsibility, but it does come with some awesome rights. As a parent, I have the responsibility of raising my daughter, of turning her from a little person that couldn't care for herself to one who could, to an educated, well-rounded, active member of society, someone who could live their life independent of others. That took a lot of work. Part of the responsibility was I was responsible, along with her mother, of doing this job of deciding what was best. What would we allow and what wouldn't we not allow? Now, at the time, most of the government said, yeah, leave them alone. Unless the child is harmed, it's not a big deal. So when I decided it was time for her to learn to ride a bicycle, I helped her learn to ride a bicycle. When it was time for her to learn to drive, I taught her to drive. When toys or videos or TV programs were available, my wife and I decided what was best for her. Sometimes to the consternation of my family. My family didn't always agree with the decisions my wife and I had made, but they recognized that was our responsibility. Which brings up an interesting thought. See, we think about the responsibility and the rights of a parent, the responsibility to raise a child and the rights to do so. But what about our responsibility as citizens? You see, we often talk about our rights, our right to free speech, our right to freedom of the press, freedom of religion, but we ever think about the responsibility that goes along with it? Sure, there's the responsibility of voting, but isn't it more than that? Is it just good enough to vote, or do you have to vet your vote? Do you have the responsibility of looking at the candidate you're considering voting for and determining if they are constitutionally sound or not? And then how about interacting with them after the vote? Informing your legislative officials, your executive branch, your law enforcement, in many cases even your judicial officers. What is our responsibility as citizens to this country that we've inherited? See, just as I had a responsibility to raise and guide my child, I have the responsibility to raise and guide those who we elect to exercise our power in our name. It's an awesome responsibility. It comes with rights, but we tend to focus on the rights and we tend to ignore the responsibilities. And I think for that reason, our country has lost this idea of what rights really means. Now, there is hope. As I said, I've been doing a Knowing Your Rights tour, helping people see that rights aren't simply something you read about in school. That if you understand rights, you can live as a free citizen. You're not bound by illegal laws. But there's a responsibility that comes along with it. There's a cost, at least a potential cost, to living as a free citizen. Are you willing to take that? Now, the Knowing Your Rights tour is a simple introduction. It's about a 1-hour talk I give, and there's time for questions and answers. And it goes into some of the basic ideas of rights and the limitations of government. But for 2022, I'm offering an online Constitution study. You can find out more at constitutionstudy.com/study. In fact, you can be one of the first people to sign up for it. Now, I'm still working on dates. So if you register your interest, you get to tell me what days of the week and what times of the day would work best for you, and that'll help me decide when I'm going to have these events. But the Constitution study is not going to be a short little one-off event. This is going to be months of online meetings where we're going to go through the entire Declaration of Independence and the Constitution so that we can better understand not just what our rights are, but the government that we created with this awesome document. I had a lot of fun doing this in person before. It's going to be interesting doing it online. So to find out more, again, go constitutionstudy.com/study. There's more information about the Constitution study at that website. You can find all the information that you want. You can ask a question. You can donate. You can sign up for the newsletter. All of that's right there. Also, please check out constitutionscholars.com. That's where those of us who wish to be students of the Constitution, scholars of the Constitution, where we get together, we share ideas, we communicate, we learn, we read, we study. Find out more again. That's constitutionstudy.com. Now, I hope you found this interesting. I hope it opened your eyes a little bit. And if you're a parent, I hope I gave you some tools that you can use should the big bad wolf of government come to vaccinate your children. Most of all, I hope you come back here next time for the Constitution study.
You have to know wherever you make your stand. Came from